Hello, everybody. We are live tonight. Hey, everyone. Hey, everyone. Doing a live tonight with one of my favorite people on Instagram, Sharon McMahon, who talks all things government, interprets, breaks things down in a really nonpartisan, straightforward way. And so excited to be with her this evening to talk through the fallout from the leak last night of the Supreme Court draft decision on abortion. Here we go. She just sent me a request, so let me just let her in here. 3, 2, 1. Hopefully she pops up. Hold on. Governor's in the house. Hello, hello, everyone. There she is.
Hello.
Hello. How are you?
I am fantastic. Thanks for inviting me.
It's been a busy 24 hours, Sharon.
This news cycle is challenging, Mosh.
Yeah, I don't know what were you doing last night when this news broke? How did you find out about it?
Yeah, no, everybody in my community is very dialed in, and I started my phone was literally like there was smoke coming out of it. You know what I mean? Like they were like, Sharon is the first person I need to tell. So that's how I found out about it, was other people needed me to know.
I recall that. Actually, it's so funny you bring that up because as Supreme Court related, it was actually the first night of Rosh Hashanah, the Jewish New Year, September of 2021, when 2020, when Ruth Bader Ginsburg passed away. And I was at dinner with the family, and like I had like 100 text messages being like, "Is this real?" Like, and I was like, "I got to take a break from the holiday. We got to make sure that people know what's going on."
I know. I feel you. You. Yes, people are saying this is a challenging news cycle, needs to go on one of your mugs, Mosh, because the people want your merch.
I know, Sharon, you and my wife both. Here we go. Here's an example of a mug.
Yeah, people are bothering. You know it's bad when people are bothering me to tell you that you need merch. Like, please tell Mosh to get merch. So there you go. Message relayed.
I appreciate you taking on the head of marketing here. We have high interest tonight, Sharon. We're like approaching about 3,300 viewers right here, and we know why. It's a major news story. You've done an incredible job in the past 24 hours breaking it down, answering. I can't even imagine how many questions you're getting. What if you were to kind of summarize for me the reaction you're getting from the folks who follow you? How would you kind of break that down today?
You know, I have not encountered anyone who feels jubilant about this. Even if they are very pro-life, even if they feel like this is what I've been working for, this is what I was hoping for, there is still a feeling of like, oh, we need to do more to support people who are going to be facing more difficulties. Like we need to do more to support single moms. We need to do more. It's not enough to just ban abortion. That is a lot of what I'm hearing from people who are pro-life, that they don't feel like it's just enough to eliminate abortion. And people who are pro-choice, as you can imagine, are very concerned. I'm hearing a lot of highly concerned, high emotion comments from people today.
Yeah, I want to start with just as someone who has studied the Supreme Court, has taught many folks about the Supreme Court. Just explain to folks how rare this is. What a big deal. I think it was about 8:35 p.m. Eastern last night that Politico had a leaked draft of an opinion.
It's never happened before. That's how rare it is. It's never happened before. There have been a couple of other leaks in Supreme Court history, but never a leaked draft of a full opinion. Leaks have occurred where a reporter was able to get a scoop by making a bunch of phone calls of like, what's the deal? What's going to happen? In fact, that happened with Roe versus Wade. It happened with the Time reporter for Roe versus Wade. In fact, Time has a link up today, like rerunning its coverage of the scoop that they got about Roe versus Wade. But the idea that a leaked full draft was obtained is very monumental. It's a big deal.
The speculation today, a lot of people are speculating what was the motivation of the leaker or leakers.
Yep.
And there have been arguments trying to explain that it might have come from the conservative side to lock in the vote. And then some people are arguing it clearly came from the liberal side to ensure there's outrage out there. Can you break down kind of where the motive, and of course, you know, like in this online era, like some people are like, maybe he just put, you know, he or she put in the wrong email address and accidentally sent it to a reporter. And it's totally an accident. Skeptical of that one, though. I can see your face. Break down what would be the motivation of someone potentially who agrees with the decision and someone who disagrees with the decision, and why each one might have a motivation here to get this out there.
Okay, first of all, I want to know if you noticed this, that the first page of the opinion, you know, which just has the title, etc., has a highlight, has in the upper right-hand corner, like the little stamp that they put on it that shows that the justices have signed off. The first page is a skew. It's not centered on the page. It's not, it doesn't look like it was just printed off of a document. It does not appear to have just been a printed copy. So to me, that, again, I'm just being super sleuth here. To me, that indicates some kind of access to a printed document. Do you know what I'm saying? Does that, can you picture the askew first page? Yes. So to me, that doesn't mean like, oh, I hacked the email and I got a copy. So to me, it means access to a printed document. Perhaps they made a photocopy of it and they were trying to do it quickly, and it possible that they used a scan app on a phone, although my scan app actually does a pretty good job of centering pages. So anyway, all that to say, my assumption is that they had access to a printed copy. Now, there are sort of two schools of thought about why would somebody do this. If somebody leaked it from the left, the school of thought is that this buys Congress extra time to do some kind of, pass some kind of law, because of course the Congress scurries away for a big chunk of the summer. And so this gives them a couple of extra weeks potentially to pass some kind of law codifying the right to seek an abortion. That's one way of looking at it. I don't happen to agree with that perspective. The other side is that they wanted to, this is the, you know, sort of the insider intel that some people have said that they are, you know, speculating about, that somebody in the majority is waffling. Somebody in the majority, currently in the majority, is on the fence. And leaking who is currently in the majority is a way to solidify their opinion and to make it seem, make it much more difficult for them to change their mind. So if the majority is these 5 people and you have somebody who's waffling, and then the actual final draft comes out and it's not the people you thought, that is a much more bitter pill. People want to seem like they know what they're doing, they know what they're talking about, and they want to be, you know, project this air of certainty. So those are sort of the two arguments. What I personally don't agree that it was, the motivation was to get Congress to pass a law. What do you think?
You know, it's so interesting because like last night, my immediate reaction was like, okay, you know, this is clearly someone who disagreed with the decision and they want, you know, protests in the streets and they want to show the court, you know, the court, you know, traditionally doesn't let, and I'd love to get your perspective on this, public opinion officially should not impact the court. It's about the Constitution and the legalities of things. That said, if you see, you know, hundreds of thousands of Americans marching the street for the next 7 weeks, even Supreme Court justices would notice that and it might have an impact. So last night I'm like, well, it clearly came from the left. And then I started to see these arguments about, as you go through the process, locking in the majority, you know, and leaking who's in that 5 vote majority. And I think right now the target is Kavanaugh. It seemed like Kavanaugh, based on his voting record, might be the loosest or the most potentially flexible to come over to the Roberts side of some sort of middle ground. And it's like, all right, Dave, that has some merits, and none of them want to be embarrassed by the fact that I've changed my vote based on public reaction. I don't know, Sharon, I'm split. I feel like even when we spoke earlier today, I was like leaning towards the right, and then I'm like kind of back to the left tonight. So it's hard to say. I mean, the big question I got from a bunch of folks is, what are the ramifications, Sharon, do we know, about the leak. Well, first of all, what do you think the leak says about the state of our Supreme Court and our institution? And then more specifically, what happens to the leaker once they're found? Is this illegal? People are saying, will this person go to jail? What do we know?
Okay, so what is likely to happen to the leaker? There's, they've already announced, John Roberts issued an opinion today or a statement today saying that he's directing the marshal of the Supreme Court to undertake an investigation to figure out who it is. There's a finite number of people it can be, right? We're not talking like there is 60 something people with access to these materials. So there's a finite number of people it could be. There's a very high chance that that person will lose their job. High chance that person will lose their job. Very, very low chance that anything will happen to them legally. There is not a federal law that is like, and if you are clerking in the Supreme Court, you cannot leak any documents. That's not a federal law. So it's difficult to say, prosecute them. The only time I can imagine somebody being prosecuted for this is if something was truly stolen. As if somebody broke into an office,
right,
rifled through papers, took it, and, ran out of the Supreme Court, breaking and entering, different story. But actually just leaking to a reporter is not illegal. In terms of what it says about the Supreme Court, I do think it indicates a certain level of internal strife. Do you agree with that? Do you agree that it is, at least on some level, reflective of the strife that is present within the inner workings of the court?
It's so interesting, Sharon, because we've come to expect, as somebody who covered Washington, my favorite place to cover was Capitol Hill because you could get leaks every day. You were inundated. Absolutely. There were so many leaks, I couldn't cover all the leaks. They're well, right. why aren't you covering my leak? And I'm like, well, there's 535 members of Congress and senators. And frankly, of the leaks I've gotten today, this is not the most interesting. The White House leaks, the Pentagon leaks, the State Department leaks, everything leaks. And the Supreme Court, for so long, we hold it, despite the fact that it's appointed, the justices are appointed by presidents with a D or an R after their names. We've kind of, for a long time, it was political but apolitical, right? It was above the law, we trust. And it just so happens we live in this era now. It's frustrating because, especially in the past few years, whether it's the CDC, the FBI, there's no institution that is immune now from politics. We're watching Disney versus the state of Florida right now. You're like Mickey Mouse, no matter where you turn, everything is political. And so, to me, I guess my reaction is the Supreme Court is like everything else. But I should also be surprised if you look at the votes, and you could take people through this, over the course of the past 25 years, we used to live in a world where despite an R or a D after your name, if the nominee was qualified, you voted for them.
That's
right.
You
have 70-30 votes, 80-20 votes. And that's changed over the last few years, right?
That's right. If you think about, the confirmation of Ruth Bader Ginsburg, where only 2 people voted against her. Only 2 voted no, I won't confirm her. And she was ideologically very, far to the left and out front about that. That was one of the reasons she was nominated. Right. But she was qualified. She was highly qualified. And so she was confirmed, and senators were like, listen, I can't argue with the fact that she's qualified, even if I don't care for her. That obviously has dramatically changed. So, there's been rumblings about disagreement amongst court members over things like masks. And then, of course, they were very quick, when a reporter printed a story saying that Sonia Sotomayor, who is diabetic, was refraining from hearing arguments in person because nobody else would wear a mask anymore. And there was conflict between them. This is what the story said. They immediately, the next day, were like, we are shocked that this is a story. That is not true at all. They immediately tamped it down. And so that is one of the ways that I feel like I knew that this leak was legitimate, is they are so quick to, or they were just a few months ago, so quick to be like, nope, that's not true. The fact that they didn't do that made it seem more legitimate to me.
And of course, the Chief Justice Roberts today confirmed it in his statement, both condemning the leak and then saying this is not the final opinion. And I would love to get into the opinion itself, because I know, I think last night I was doing a live, and I was like, everyone's like, well, you need to get Sharon on here. Your governors were in full effect last night, and I was like, I'm sure she's reading the opinion right now.
Yeah.
You have read the opinion.
Yeah.
What are the major headlines from you of the opinion? 49 years after Roe v. Wade. How does this draft opinion, again from February, there clearly have been subsequent, or we're told this is not the last one.
That's right.
How does Justice Alito break down his argument, and presumably the argument that is supported by at least 4 other justices?
Yep. I said to some people earlier today that it was like he wrote this opinion with a blowtorch. That is the best way I can describe it. Both his tone, his word choice, his argumentation, it was written with a blowtorch. And it was not a thread the needle, find a middle way. No, not at all. He absolutely excoriated the logic, the reasoning, all of the things that went into the makings of Roe, and also Planned Parenthood versus Casey. His main points are that the Constitution is silent on abortion. And thus, if we are going to say the right to abortion is an unenumerated right, if we're going to say, well, it doesn't say abortion, but it does say there are unenumerated rights. If we're going to use this, presumption of an unenumerated right, we need to examine 2 factors, and we need to see if that criteria is met. And one of those is, do we have a long history? Is it deeply rooted in our history and traditions? That's the language that he used. And he found that no, legal abortion is not deeply rooted in our history and traditions. You can argue that abortion is deeply rooted in history, because it is. It's existed ever since human society has existed. But what Alito is referring to there is a deeply rooted legal history. And then the other reason has to do with, does it have to do with our ordered liberty? Ordered liberty is the phrase that he uses. And he argues that liberty is not without limits, and that an ordered liberty is what we need. So he gave a couple of examples, like people don't have unlimited freedom to do with their bodies what they will. And he gave examples of illegal drugs and prostitution. That an ordered liberty does not mean that all people can do all things at all times. So but the end result of that legal wrangling of that's how he got in the on-ramp of his end result, which is that because it is not part of our deeply rooted history and tradition, it's not part of an ordered liberty, and it's not mentioned in the Constitution, that this opinion, or this Roe versus Wade opinion, Planned Parenthood versus Casey opinion, is gone. And that the matter needs to be left between voters and their representatives.
It's been, it was interesting to look back at the history of Roe. It comes out in 73. We were talking a bit about this earlier. It's a 7-2 majority, including, I think, was it 5 justices appointed by Republican presidents?
Yep.
And the evolution that we've now gotten to 49 years later, now in this case, a majority of conservative justices appointed by Republican presidents have now found the opposite, or at least appears so. Has conservative thought, how has it evolved on abortion? How is it that, we went from 1973, where a majority of the conservatives were in support of this, to today?
You can see a very fast-moving progression towards the end of the 1970s, beginning of the 1980s. During the rise, if you trace the history of the Republican Party, and by the way, there's a fantastic book, if you're interested in the history of the Republican Party, called The Right. And it's written by a conservative, and it is the 100-year history of the Republican Party. And it's really very, very interesting. He talks quite a bit about this in this book. But towards the end of the 1970s, early 1980s, you see the sort of condensing down of factions, where Republicans began to realize that in order to make legislative progress, they were going to need to coalesce around a couple of central themes. And one of those central themes that particularly one group of movement conservatives were interested in was, like the moral majority was interested in this idea of abortion. Prior to that, you don't see that same level of sort of more religious right. You don't see that same level of support for pro-life positions. In fact, if you look early in the 1970s, the largest evangelical group in the United States is the Southern Baptists. And earlier in the 1970s, the Southern Baptist Convention twice affirmed their position that abortion should be between a woman and her doctor. And so you see, like, it is a very fast progression from early 70s to early 80s around this coalition that was built called the moral majority, in which they believed that that could be an idea that they could come together on.
So AZ Rollins asks, is the SCOTUS opinion sound in Sharon's opinion, Justice McMahon?
Is it sound in my
opinion? Is it
sound?
Like,
is it well written?
I guess, by the way, there's a whole bunch of folks here in the comments who are, I guess, via Instagram nominating you to be the next Supreme Court Justice.
I'm so qualified, super qualified. Thank you.
Yeah.
I could be, or as your promo earlier said, Supreme Bombshell.
You like that? You like the double entendre there, Sharon?
So many people were mentioning that to me and I didn't get it. I'm like, what are you talking about? Until they said it to me. That was fantastic. No. Okay, what was the question? I got sidetracked.
The question from one person was, is the opinion sound in your reading? Or I guess another way to ask it, is the legal reasoning behind it based on that draft. In reading it, what was your reaction?
Here is one of the questions that I feel is completely unanswered by Alito in his opinion. By the way, one of the things that he did mention was that there is a lower need for abortion now than there was in the past because of societal changes. For example, societal attitudes that have changed surrounding unwed pregnancy, the availability of things like adoption, the availability of safe havens where you can drop your baby off if you are unable to care for it. So his position was part of his position as well. But here's the thing that he does not mention, which is this idea that something is deeply rooted in our history and tradition, and that nobody complained when abortion began to be made illegal around various states in the mid 1800s. That nobody complained, nobody raised it as an issue. My question about that is that women were not part of that equation, right? That when we say nobody raised it as an issue, women couldn't vote in the mid 1800s. So that is the one thing that I feel is unaddressed by this opinion, is there's a complete, almost like an ignoring of the fact that, number one, women were not part of the equation. And so when they say no one complained, he means no men complained. The other thing too that I think is, that I find interesting, that I need to, think about some more, is that there are many other things that are deeply rooted in our history and tradition, legal history and tradition, like slavery, right, that we absolutely should agree we should not carry forward despite having a deeply rooted history and tradition. So for me personally, again, this is not about abortion or pro-life, pro-choice. That's not what this is about. These are just my questions about the logic, the legal logic that is used in this opinion. Those are two areas that I feel like I need more clarification on the legal logic, and maybe that will come in the final opinion.
Yeah, and I wanted to get to that because a lot of the questions I got was like, explain how many drafts do these justices go through? Explain the process. So this all has to do with a case they heard in December about a Mississippi law that would ban abortion after 15 weeks. Mm-hmm. And the question that came up was, would they just go with a narrow ruling on the law?
That's right.
Or would they use this to completely reimagine the court's role when it comes to abortion. So take us through the process. How many drafts do they go through, and what were the possibilities here?
Well, it's impossible to know exactly how many drafts they go through because the court is traditionally super secretive. Right? Like they purposely don't tell us these things. And this is, like when I teach workshops about Supreme Court opinions, these are the things that people want to know. They're curious about. They're like, well, why did they choose to hear the Mississippi case, but they didn't hear this case? We want that information. Like, what made you pick this case? And they don't tell us. They never tell us. They're never going to be like, we chose Mississippi, v. Dobbs v. Jackson because the following reasons. They're not ever going to tell you that. So we don't necessarily know how many drafts, but it is always more than one. And there's also a good chance that this is not even, like the first iteration, that it's quite possible that they had prior iterations before typing up all 90 plus pages. And then, so to just walk you through the process, when they have oral arguments, they usually have oral arguments on set days of the week. They have oral arguments on Monday, Tuesday, and Thursday. And then they have conferences on Wednesdays and Fridays. And those conferences are where they meet amongst themselves. And they usually they talk about on Wednesdays, they talk about the Monday cases. And on Fridays, they talk about the Tuesdays and Thursday cases. Or thereabouts. Sometimes things mix up, like the dates. But that's the general gist. It's 3 days of hearings and then 2 days of conferences. They then have a couple of, they probably have a couple of days to think about something before they meet as a group. They will probably talk about it with their clerks. Each of them has several clerks who are highly bright attorneys from the best law schools, generally speaking. And so they often will go into a conference with a general idea of how they might vote. Then they go down in order of seniority, and each person has the opportunity to speak about their opinion on this topic without interruption. That's like part of the rule. No interruption by seniority. So Roberts being the chief, he automatically has the most seniority, and then they just go down the line. Then once everybody has a chance to speak, then they go through again, beginning with Roberts and going all the way down to Barrett. That will eventually be Jackson, who is the least senior. And then they each get a chance to vote. And then they see, where are we? Okay, who is in the majority here? And the way they determine who is going to write an opinion is whoever is the most senior justice in the court's majority assigns who will write it. So Thomas has been on the court for a very long time. He was the most senior justice in the court's majority. And so he assigned Alito to write this case.
Clarence doesn't often write many opinions.
Nope. Yeah. He is not the most verbose person on the court. He doesn't say much and he doesn't write much. And it is always, a lot of times, even in his dissents will say, I dissent. You know what I mean? So that is not that unusual for him. Yeah. So no, he perhaps wanted some of that Alito fire. Thomas is more reserved. He's not that like super fiery personality, and perhaps he wanted that Alito fire in drafting this opinion.
Everyone wants to know what happens now. I mean, regardless of the motivation of the leaker, it is now out there. We don't know where the vote has gone since it was 5-4, presumably in February. We're in sort of an unprecedented situation. Typically, this decision would come out, the last week of June?
Sometime in June or July.
What happens next, Sharon?
They're going to write more versions. I can almost promise you that they've already written more versions because this was written in February and there are probably already more drafts written. Yeah. So again, we don't know the precise number of drafts they will go through. I can't promise that they aren't reading all of the New York Times articles and being like, well, I need to clear that up.
Well, that's the thing. To what extent do we know through interviews they've done how much attention they're paying to media coverage of these decisions?
They always say that it does not matter to them, right? Like that is almost always what they say, that they are apolitical. They're not a political body. And even Alito even mentioned this at the end of his opinion. He said, the court does not pretend to know what kind of ramifications this decision will have, but we do not have the authority, in his opinion, we do not have the authority to expand the court's ability to, essentially what he's saying is, we don't have the right to legislate from the bench. That is up to the legislature. So they always say that it's very, very, they don't pay much attention at all to the court of public opinion. And you can see that in this case. You can see that in this case. The court of public opinion is that, generally speaking, many Americans believe that some restrictions on abortion are good and permissible. But they don't want to see it become completely illegal. Somewhere between 60 to 70% of Americans feel that way, depending on, the methodology and the polls that you look at. So if they were just making their decisions based on what Americans want, it would be, the opinion wouldn't look the way it does.
Right. We have a question here from Joanne, who says, what about precedent? Sharon, explain the idea of precedent. A lot was made in the past 24 hours. Everyone's pulling the clips of Barrett, Kavanaugh, and Gorsuch, most recently speaking about precedent when it comes to Roe v. Wade. But explain the idea of precedent and how, applying precedent in this case might have led some of these justices to, vote against the Roe v. Wade decision.
So the Supreme Court voluntarily and by tradition uses this concept of stare decisis, which is Latin for essentially let the decision stand. It's a Latin term for precedent. There is no law that says they must use precedent. It is legal tradition. And one of the reasons they use precedent, so let's say they make a ruling about something like whether or not girls are entitled to an equal education to boys, just making this up. Then the next time they are faced with a case that asks the same question, they have their previous legal reasoning to fall back on. You don't want them actually to make a brand new decision every single time. And the reason for that is because it leads to the potential for an incredible amount of inequity, where they are not applying the same standards to everybody. It's essentially deciding on a standard and applying that in every manner in which it makes sense. So you want them to apply the same standards. The other reason that that's important is that it helps lower courts understand, what are we supposed to do here? Well, let's look at prior court precedent. They think girls have the same right to an education as boys. That's what they have determined. So prior court precedent also impacts lower courts. It impacts legal students. It impacts a huge variety of things. So court precedent is very important. So for them to abandon prior court precedent, to essentially turn their back on prior court precedent of two very landmark cases. Landmark means like highly important, very consequential. To turn their back on the precedent of two landmark cases is highly unusual. And that is one of the reasons you are seeing people making a big issue of it. You're seeing a lot of news organizations play clips of the confirmation hearings of people like Barrett, Kavanaugh, Gorsuch, where they were specifically asked by Congress about Roe versus Wade, and they talked about things like the importance of prior court precedent. We even saw some members of Congress like Susan Collins, et cetera, say that is not what they told us in their hearings. They said they were committed to the precedent of Roe. So abandoning the precedent set by a very monumental case or cases is a very big deal. It rarely happens.
I have a quick question here from Cookie LB. How does this change the idea of privacy? Privacy issues. And by the way, I want to get into, I'm getting questions from folks. How does it impact same-sex marriage? I'm in an interracial marriage. Should I be afraid? Someone asks. Medical privacy. So this whole idea of privacy, I think it's in regards to, is it the 14th Amendment? Yeah.
So one of the things that Alito did in this opinion was he talked about how Roe's conjuring of a right to privacy. So a lot of times people misunderstand the basis on which the Supreme Court determined that abortion was legal in 1973. They think it's that, they decided that women are, allowed to do whatever they, like they have the freedom to do whatever they want, or they think it has some kind of, they just think abortions should be, we shouldn't make those kinds of things illegal. The basis on which they made that decision was based in part on privacy issues. And so, and the idea that a state should only step in and begin to regulate things when their interest in protecting life outweighs a woman's right to privacy with decisions with, in medical decisions with her physician. So when you are, one of the things Alito said was this conjuring of the right to privacy. The legal term is these penumbras and emanations. Like, we can't put our finger on where privacy comes from, but we know it's in there. And when they're talking about a penumbra, if you think about a penumbra being like if you put up an umbrella, and then the shadow that is cast by the umbrella, that's often referred to like as a penumbra. It's just like the shadow is not just within.
I didn't know that. I'm
Yes.
going to try to use that as often as possible. A penumbra.
The shadow is larger than the actual object itself, right? So this idea that there are penumbras and emanations of privacy within the Constitution, that Alito, no, he does not agree with that. He says, he's like, show me where it says it, and it doesn't, and you can't. You can't show me where it says a right to privacy. So this does then potentially raise other questions. And to speak to the people who are saying, well, what about Loving versus Virginia? What about Obergefell versus Hodges? These are questions about interracial marriage, questions about same-sex marriage. If those are not unenumerated rights, as the Supreme Court has previously held, if those are not unenumerated rights, is there a potential that other things like these unenumerated rights of same-sex marriage, et cetera, is there a potential that those could be under attack? And I can't say that there isn't potential. In fact, Alito brought those things up in his opinion. He said this, essentially this opinion won't have any bearing on things like same-sex marriage. But he did allude to it. He did allude to, here are sort of the legal arguments that one might make if they were going to attack those institutions of things like interracial marriage and same-sex marriage. That there is no unenumerated right that is not deeply rooted in our legal history and tradition and is part of a well-ordered liberty.
Right, gay marriage. Gay marriage is not even 10 years old.
That's right. I don't think you can make an argument that same-sex marriage, and again, I'm saying I don't think Alito can make an argument that same-sex marriage is deeply rooted in our history and tradition, legal history and tradition.
Yeah, I'm gonna be fascinated to see what the final draft. Well, first of all, does it remain 5-4? What happens? But whether this February 10th iteration of the draft, whether anyone had said notes being like, how do you make these two things where you say this won't impact things like this, and yet you make an argument that it could impact decisions like gay marriage, and how they go through that revision process, because it seems like legally you want your argument to be coherent. Yes.
Right. You want it to be well understood so that it can be easily applied. If it's not well understood, it's difficult to apply. And the purpose of having made the ruling in the beginning, to begin with, is essentially moot.
While you were just addressing all of that, I think there were 6 or 7 questions about IVF, how this would impact potential legal cases in regards to IVF and the fetuses. To what extent have you looked into that, or do you have any sense of, are there any legal cases pending?
There are legal cases pending related to IVF. I wouldn't say that I have a strong spidey sense of ooh, IVF is next. I don't see that. But that doesn't mean there aren't pending legal cases. And one of the things that some people have a question mark about related to IVF is if the state's belief is that life begins at conception. Does that extend to conception that has medical assistance, like IVF? And for some state lawmakers, it might. It might extend to, doesn't matter where the conception occurs. If the belief is that, a soul is present at the moment of conception, it doesn't matter where the conception occurs. So some people believe that. Many people don't believe that. But I don't see a strong movement swing away from IVF, like making it illegal. But there are some court challenges from some pro-life groups who want to see, because, for example, there have been 1.7 million embryos discarded over the last 10 years or so via IVF. And the most common method of discarding embryos is to throw them in the trash. That's not my opinion. that is actual people who study these things. What is the method of discarding, etc. And then there are, of course, many millions of embryos that are frozen, etc. That would be a very, very sticky legal problem to untangle. Very.
Yeah. I mean, like I've told many people, like, this is very, it's unclear what sorts of cases we're going to see come out of this and how the court might rule, because a lot of it will also be based on the rationale, the final rationale.
That's right.
If the court is to overturn the precedent they use, and then the legal interpretation. I mean, even, it's been fascinating to watch the last couple of years, Texas take a creative tack
yes.
On abortion. And what becomes of that? And, this gets to the larger question of, like, what becomes of the 50 states now, should this precedent be overturned?
That's a great question. So as of this moment, it appears as though 24 of the 50 states will move to either completely banning abortion or strongly restricting abortion quite quickly. It is, however, possible that as societal ideas change, as other people win elections, that those positions of a state, that there could be a pendulum that is swung. I think it's probably a low pendulum, a low speed pendulum. I don't think it's going to be like a, whoa, that just knocked us over. But I think it's possible that either in some states that are more swing states, like if you think about states like Wisconsin or Ohio that tend to be less deeply entrenched in one political ideology, I think you might be more prone to see some of that pendulum's creep over time. But right now, it appears as about 24 of the 50 states will either outlaw or greatly restrict abortion. In terms of these more unusual and unique schemes that states like Texas have enacted, and by the way, scheme is a legal term in this concept, or in this context.
Thanks for clarifying.
Yeah, we tend to use scheme as a, like, ooh, you're a schemer. Ooh, that's negative. That's bad. What kind of scheme do you have? Scheme is an actual legal term in this that the Supreme Court uses. Supreme Court, in fact, referred to Texas's law that allows people to sue each other. They refer to it as a scheme. So the Supreme Court still has not made, a final determination on whether or not that passes muster. And there's a chance that some states like Texas could allow it to remain because it frees up government enforcement. It frees up them not having to have, an office or a person or group investigating these things. And it just allows the citizens to handle the situation. So I think it's possible that some states will continue with those, but most states will not go that direction. Most states will go with some form of government oversight in a ban or a restriction.
Here with Sharon McMahon. Sharon says so.
Hello.
I'm Moshe, for all you Sharon governors who are like in the comments, like, who's this guy? I'm a journalist based in New York who curates news on Instagram, and I appreciate most of you are behaving yourselves in the comments as I see scrolling. So thanks everyone for having a productive conversation. Otherwise, we'll send Sharon to your home.
I like how I am going to be the bad guy in this scenario.
Fine,
Not
fine.
you.
I'll be the bad guy. I'll be the bad guy.
You're going to go to their homes.
Okay, fine, Sharon.
Okay.
You're
right.
good cop. I'm bad cop in this case. So the big question we got from a bunch of folks is, what can the president do? The president's a Democrat. The president's a pro-choice Democrat. What can Congress do? Democrats currently have a slim majority in the House and a majority when you count the vice president, the Senate. What can they do about this federally?
Okay, so what can the president do about a Supreme Court opinion he doesn't like or does not agree with? And there's really no question that Biden doesn't agree with this. The answer is nothing. No things. Zero things. People have asked me all day where they're like, can he write an executive order? No things can the president do. Really what the president can do is try to lean on Congress. But of course, the president can't even get Congress to pass something under normal circumstances. So he can lean on Congress to try to do something about it. He can say, I'll sign it into law. But there's nothing he can do directly about a Supreme Court opinion he disagrees with. What can Congress do? Congress also cannot be like, erase, overruled, don't agree. They don't have that right either. So neither Congress nor the president, again, this is what checks and balances, has dealt us, that you have one organization that's the height of the judicial branch and the other height of the executive and the legislative branches can't just overrule them. What that would create is, one all-powerful entity in the United States, which you don't want. So, but what Congress can do is Congress can write a law if they want to. They can write a law, and you probably have heard people today talking about codifying the right to an abortion. People have asked me, and I haven't had a chance to answer this yet. What does codifying the right to an abortion mean? It's a reference to the United States Code, which is our actual giant books full of laws. Those are referred to as U.S. Code. So they can codify the right to access an abortion at the federal level if they want to. They could make it like the Voting Rights Act, or they could make it like Title IX. They could codify it at the federal level if they wanted to. And here, this brings me back to my original point, Moshe, that I made when we started, which is why I don't think it is a person from the left leaking this who wants Congress to pass a law, and that's their motivation, trying to give Congress a longer runway. The reason it's not plausible is because I would like to ask them, by what mechanism will the 60-vote filibuster in the Senate be overcome?
Right.
By what mechanism? And unless you can answer that question, I don't know that that position holds water. So for people who are not familiar, in order to even bring a concept, bring a bill to the floor in the Senate, this is not true of the House, you need 60 senators to agree to even bring it up to discuss it. And that is not in the Constitution. That actually is just something the Senate has decided on for themselves, because Congress makes their own rules. They make their own rules about themselves.
We have a board Aaron Burr, according to one theory, credit for the filibuster, right?
That's right.
Post shooting Hamilton, he's bored as president of the Senate, and he rewrites some rules, and then 40 years later, they're like, oh, this thing called the filibuster.
Yep. Yes.
Yeah.
And also the way that, we won't get into the whole history of the filibuster, but the current filibuster is not at all what the original, original filibusters were like. But all that said, by what mechanism will you talk 60 senators into allowing this to come to the floor of the Senate? The other alternative would be to use what they refer to as the nuclear option and be like, scorched earth, the filibuster. We're not doing it. We have 50 Democrats. We have one Democratic vice president. We're bringing it to the floor. Two senators, Sinema and Manchin, have again, even today, issued statements saying that they do not support the elimination of the filibuster for any reason. So they don't have the votes. In the words of Thomas Jefferson, you don't have the votes. So
as reinforced by Lin-Manuel Miranda's lyrics.
That's correct.
Yeah. No, because some people in the comments are saying, well, they have an exception for the filibuster for other things, like Supreme Court justices, so why not an exception for this? But this would require all the Democrats to be unanimous in breaking the filibuster on this rule.
That's correct. And they all agreed, there was a broader agreement in the Senate to be like, fine, we have to get people confirmed. We'll agree. Okay, you guys just need a simple majority. Fine. Because it is a matter of national security in some cases to not fill cabinet positions. So that was an agreement that was struck, and both sides have continued with that sort of belief or tradition. But yes, they don't have the votes.
So a question here, by the way, my wife Alice is behind the scenes this evening. She just handed me her laptop as she's checking out comments here. We have a question from Sincerely Amy Photography. How do you think this will skew local elections? A lot of people are asking, well, the leaky might have had political intentions for midterm elections. And so, we've been talking a lot about the legal impact here, how things could change. And of course, everything is politics in this. And so we have a midterm election coming up this fall. What's your sense on how this will motivate both the left and the right?
Great question. I think it will have a much larger impact on state elections than it will on like elections for mayor. And some municipalities have all the elections on one day. And so you might see fantastic voter turnout if everything is on one ballot. If they're separated, again, depends on your region, probably less likely to motivate people to vote for like city office, for example. But for state level offices, I do think this is going to galvanize a certain subset of voter. It is probably going to galvanize most the people who are strongly pro-choice or strongly pro-life. But they are going to be highly motivated to either continue with the representation that they have, who has gotten them to the place that they want to be, or to make a significant change. And you probably will see a larger amount of money being poured into some of these state level races that are more contentious. The policy of the two major parties has been, if it's not a contentious race, if you're projected to easily win, you're getting next to no resources from us. We're not going to send you our tens of thousands of dollars if you're going to win anyway. You might see that start to change. You might see the funneling of more outside the state money into state level races as well. Money is always a factor in politics, of course, but this is going to motivate those sort of more big ticket donors, I think, to pour money into, rather than pouring money into congressional elections to the highest level possible, they may put more money into state level elections.
Yeah, I think it's so interesting because when you look at issues, Gallup and Pew, the major pollsters do month by month of like issues Americans most care about. And, it's typically economy, inflation, healthcare, education. And then there are people who, if you go farther down the list, have more smaller issues, or in this case. So it'll be very interesting given the state of the economy, et cetera, state of the world, Ukraine, et cetera, how this plays out 7 months from now.
I also think in addition to those state level legislative branch races, like who are you voting for to represent you in the New York's legislature? This is going to make governors' races even more contentious, because even if a state, if you have a Republican majority in the legislature, but then you work hard to elect a Democratic governor, then the view is like, fine, you can have all those people. We'll have our person who can just veto all of the things that you're trying to do. I think that is probably going to be a strategy of Democrats, is to try to get as many Democratic governors as possible to veto the potential laws that might be passed in Republican states.
Yeah, one of the states I've been watching here is Michigan, which is a fascinating situation because you have a Democratic governor, a Democratic attorney general and secretary of state, but then over in the legislature, one of the bodies has a Republican majority. And Michigan is a state that has a 1931 law still on the books banning abortion, which would, because when you look at the map, people are like, wait, Michigan is going to ban abortion? They never, and when Roe v. Wade happens, they never took that law off the books.
That's right. Yep. And so then when we say that there's a trigger law, or when they're, like it's immediately going to be banned, there is that issue of enforceability will they try to enforce this law that's on the books?
Right.
And some states, it may not be like, ooh, we're going to be out there right in front enforcing this. It may take them a while to remove it from the books. They may never remove it, but it also may never be enforced.
Sharon, what questions are you asking? This is 24, I mean, literally 24 hours old. How are you watching these next few days play out? I mean, we got the responses one would expect in the last 24 hours from Democratic leaders, Republican leaders. I was struck by Mitch McConnell today, who didn't want to talk about, while some Republicans were saying, I hate the leak, but this is great news. Mitch McConnell's like, just focus on the leak. The leak is terrible. It's ruining our institutions. Roberts is investigating. The FBI, is going to look into this according to some sources. What are you watching for these next days and weeks?
I mean, I think it's going to be interesting to see what kind of measures are undertaken to investigate the leak. I'm very curious about that because this again is so unprecedented. Like, is this going to trigger did somebody break in? You know what I mean? Like the intrigue.
Well, I have any conspiracy theories come into your comments today?
Has QAnon come up with anything yet?
Does it involve Vladimir Putin, Bill Gates, Fauci?
JFK back from the dead.
Right.
I'm not aware that JFK is back from the dead, nor that he's breaking into the Supreme Court. The ghost of John F. Kennedy. No. I don't think it was somebody who broke in. I think the Supreme Court would know that somebody broke in. They have a lot of security. They have their own police force.
Right.
A lot of people don't realize how many different law enforcement agencies work inside Washington, D.C. It's dozens. They have like the Supreme Court police. So you would think the Supreme Court police would know if there was a break-in. So I'm just teasing. I don't think that's what it was. But I am very, very curious about what measures will be taken to determine who the leaker was. And then the thing that I'm super curious about is, will they tell us when they find out? Or are they going to handle it real on the down low? Because all of these clerks, their time is rapidly approaching its end. Like the court wraps up its business in the beginning of July, and these clerks are done. It's a 1-year gig, like they start in September and they're done mid-July. So will they tell us who it is? I'm also super curious to know if they will ever come forward.
Yeah, well, I imagine there's some book publishers that have a pretty fat check ready for opinion editors at newspapers, cable news, anchors. Everyone is going to want to hear from this person.
Oh, absolutely. And they may, if they're smart, which they probably are because they're working at the Supreme Court, they may wish to monetize it in some way. And probably Politico wants to monetize it in some way.
It's fascinating, there's a lot of people who've been clerks. I mean, like Ted Cruz in the Senate. There's some senators who've been Supreme Court clerks, etc. Explain, people are trying to point their finger at who the suspect might be. So people point to clerks. How many clerks does each justice have typically? What does that job entail? Who are these clerks, and what do they do?
Yeah, well, each justice usually has 3 to 4. Depends on who they are and how many they need. 3 is a pretty average number. Some have 4. And each justice gets to choose their own clerks. They choose their own clerks from all of the applicants, the available applicants. And I remember listening to an interview that Scalia gave. Scalia has since passed away, but he was, sort of an icon on the more recent courts. Listened to an interview that he gave about how do you choose your clerks. And he was like, well, if I have a choice between people who are going to Ivy League law schools and people who are going to a state school, I'm picking the Ivy every time. The idea is that amongst most of the justices, that you want the absolute best of the best of the best, and that it usually, generally includes people who are attending like the highest level Ivies. Of course, there are some great schools like Stanford that's not technically an Ivy League, but you want those like top tier law schools for your clerks. So they are law school graduates. Some have already clerked on another level of court. or they may have clerked at a lower level of a federal court and then are applying, but many times they're applying directly to the Supreme Court. And what clerks do is often between them and the justice. There's no federal law that's like, here's the job description of a clerk. They do what the justice asks them to do. And so it's very feasible to assume that some justices are much more involved with their clerks than others are in terms of how much work does the clerk have. So clerks do things like, the Supreme Court gets 7,000 approximately requests every year of like, please hear my case. And they choose about 100. And so somebody needs to read the 7,000 requests. And when I say 7,000 requests, yes, they write like a little brief. They write like a little memo of like, please hear our case. But they also have to review all of the lower court transcripts. It is not an easy feat to consider a request. So justices might say to their clerks, listen, I'm very interested in hearing cases about things related to certain types of immunity, like the immunity that police officers might have. I'm interested in hearing cases about immunity. And so it's possible that they give their clerk, and we actually have evidence of this, give their clerk a topic to look through. Give me all of your, come up, I'll go through them all, figure out all the qualified immunity cases, and then we're going to sit down and figure out which one we want the most. So they do a lot of that like pre-reading. They also do a lot of research on legal citations. When you see, for example, this draft opinion written by Alito has 30 pages of citations. 30. Somebody needs to write those. And that is almost always a clerk.
Right. And these go back hundreds of years.
Yes.
Yeah.
Yes. Dig it up. That is your job to do that legal research. And then to some extent, they may help with drafting opinions. They may help with some of the writing. And again, justices would tailor that based on their own preferences.
All right. So you've been with me an hour this evening, and I'm so grateful. And just a couple more. Do you have a couple more minutes for a couple more questions?
Yeah.
Sharon?
Yep.
Okay. There's been a few questions about undue burden, the undue burden standard, and why this isn't discrimination against women.
Okay, so undue burden is a phrase or a legal concept that was established in the case Planned Parenthood versus Casey. And what Casey did came well after Roe is it abandoned some of the legal framework that was established in Roe, particularly this trimester system that was established in Roe. It abandoned some of the legal reasoning, but maintained the final result of abortion should remain legal in all 50 states. And it established something called an undue burden test. And the way that they began to determine whether or not a restriction on abortion should be legal or not is, does it pose an undue burden on a woman's access to abortion? So I'll give you an example of this. There was a state that wanted to have a list of about 5 restrictions on abortion, including 24-hour waiting period, mandatory ultrasound, have to notify your husband, get your husband's permission, etc. So what the Supreme Court did then was they went through those restrictions and asked themselves, does this pose an undue burden? Which you can assume means an obstacle too significant, an obstacle that is too significant to somebody seeking an abortion. And it found that things like mandatory waiting periods, ultrasounds, mandatory ultrasounds, they just determined that those did not pose an undue burden. But notifying your husband did pose an undue burden, that might be too large of an obstacle to overcome. So for many years, for decades, the Supreme Court has used an undue burden test to determine whether or not a restriction is permissible. Does it place too large of an obstacle in the path of somebody seeking an abortion? So people then have been asking me, and I know they've been asking you, how is this not sex-based discrimination? Because the Constitution does prohibit sex-based discrimination. And Alito's reasoning is that this is not a law that is the intent. If a state passes a law restricting abortion, the intent is not to discriminate against women. The intent of the law is to protect potential life. He uses the phrase potential life. And so consequently, it cannot be discriminatory if there is some larger issue at play. It's not discriminatory for a state legislature to want to protect potential life. That's what Alito says.
So just basically reimagining the argument that it's like, I'm focused on this and not that. Of course, there are folks who disagree with that. There's also questions in regards to attempts to ban people from leaving the state for abortion. So, for example, now this goes to the states. In your state, it's legal to have an abortion. And in the neighboring state or nearby state, it is legal. Can the state that bans it prevent its citizens or residents from going to another state?
Okay, states cannot regulate interstate commerce. That is in the Constitution, that is a federal government's job to regulate interstate commerce. So the state of Washington, for example, cannot say, listen here, no one is allowed to leave. You are not driving to Idaho. Like that, you can't do that, right? That's not a thing that can happen. So the answer on a broad sense is no, you cannot prohibit a person from leaving the state. But that has created a unique opportunity for some states like Missouri to concoct a legal scheme, and again, scheme is a legal term in this sense, that permits family members of Missouri residents, permits them the ability to file a lawsuit against somebody who helps that Missouri resident cross state lines to seek an abortion. So if you have Jane Doe wanting to cross Missouri lines to go to Illinois to seek an abortion in Illinois, and Jane's friend Susan assists her, drives her there, this law potentially would permit family members of Jane to sue Susan, saying you helped a Missouri resident cross state lines to seek an abortion. So again, it's that civil enforcement, the same type of scheme that you see in Idaho, you see in Texas, where one person can sue another person for money, not the same as criminalizing it where somebody will go to jail, but it permits a lawsuit for money if somebody assists a mother in crossing state lines, and that mother is a Missouri resident.
Got it. So it's almost similar to how Texas has been approaching things, where you're basically having some citizens sue others civilly.
That's right.
And the state is out of it. Sharon, I understand you have a class about abortion that people can take.
I do. I taught it a while ago, but it is highly informative. It has basically all the prior Supreme Court cases. It certainly doesn't have the one that just was leaked yesterday. But it has all the previous Supreme Court cases that somebody can, if you're interested in the legal basis of abortion, on what basis the Supreme Court has made decisions in the past, what limitations are acceptable, etc. It's not a class that will try to convince you to be pro-life or pro-choice. It's just for informational purposes, so you can be a better informed citizen. That's on my website if somebody's interested in that.
All right, so people can head over to your website to go take that class.
Yep, they can download it.
In fact, there's a lot of, you're getting a lot of endorsements in the comments right now about so good.
That's cute.
Oh, and by the way, for all of you who are curious, this live will be saved. And hopefully relevant for at least a few days until this news cycle evolves in some other way. And we'll have to do this all over again.
And then you better have a mug by that time that says, this is a challenging news cycle.
So I like, this is a challenging news cycle. I also, one of the suggestions that has come to me, Sharon, is I'm ready for some precedented times.
Yeah. A sign on 100 emoji. I'm ready for some precedented times.
We've had 2 years of unprecedented, and I'm hopeful but not optimistic.
Yes.
One final question here from Susie MH. Do you think the leak, and I'm trying to put you on the spot, sorry to put you on the spot here, would be considered and protected under a whistleblower act in some way? You know, a lot of people are like, you know, so we know this person clearly broke a rule, and when they discover it, this person will probably be fired. There are questions about disbarment, potential criminal or civil or whatever, and is there whistleblower act protection? What do we know?
Whistleblower Act, no. That is designed to protect somebody legally who is exposing some kind of criminal activity or illegal activity, you know, on the part of a business or whatever. Like your business is violating environmental laws and you let everybody know, and then it's illegal for them to fire you. Or, you know what I mean? Like that's what a whistleblower act is supposed to do. So that's not what's happening here. Is it, however, possible? So here's another thing that a lot of people don't know is that the Supreme Court has its own bar association. In addition to every state having their own bar, the Supreme Court has its own bar. And so in order to argue a case for the Supreme Court, you have to be a member of the Supreme Court Bar Association. So it's entirely possible that the Supreme Court could decide to disbar somebody who was a leaker, assuming they already are in the Supreme Court bar.
And assuming they're not a Supreme Court justice.
But, you know, again, I think it's quite possible that they might be like, listen, you cannot be in this bar association anymore. You violated our trust. But not disbarment necessarily from, like, let's say they're from New York, not necessarily disbarment from the New York Bar Association.
Sharon, so grateful to you for your time. Thank you for answering so many questions. I know that there's thousands coming at you every day.
Likewise.
It's a weekly thing.
There's Alex tells me that a lot of people in the comments are saying we need to do this weekly, Sharon.
People tell me that all the time too. I mean, in addition to telling me that I need to tell you to get merch,
yes,
people tell me to tell you, can you get together more often? Because they find it useful and entertaining.
And I will also have you know that people tell me to tell you that people tell me to tell you that you should get several politicians should spend more time on your page.
That's right. More members of Congress need to be reading this information.
And by the way, on a total side note, Alex tells me there's questions about your eyeshadow tonight, Sharon.
Oh.
What are you wearing?
Oh, this is Charlotte Tilbury. This is the Pillow Talk palette.
Can we get that if we buy your abortion class on your website?
No, Charlotte Tilbury charges a lot more than I do.
Anyway, I appreciate you. This obviously is a very serious topic with serious ramifications. But as always, we try to bring some insights and some calm facts to the floor to everyone. So, and we will keep doing that. And maybe folks will get their wish at some point. And we can do this thing weekly, Sharon. You just got to find more hours in the week.
Just sleep less. That's the answer. Sleep fewer hours.
Sleep fewer hours. Anyway, have a wonderful evening and wonderful rest of your week. And thanks to all of you tonight for watching.
We'll do this again soon. Good night, everyone.
Good night.